Hi, this is Dominic Fiscuso with Your Home Imagined, and today we're going to talk about emotional support animals. Do landlords have to accept emotional support animals? And the short answer is yes. Landlords must allow a tenant with a valid emotional support animal letter to rent the unit with no consideration of the pet, the type of animal, the breed, or the size. The only reason a tenant can be denied is if it is proven evidence that the animal it constitutes a direct threat to the health and safety of others or would cause substantial physical damage to the property. In this video, I'm going to go over reasons to deny an ESA animal, what a valid ESA letter is, what must be on a valid ESA letter, and the possibility of pet screening. I am not a lawyer, and this is not legal advice. This is only to bring up conversation that you may want to have with your attorney. Say you have a rental unit, and a potential tenant puts in an application. Seems like a home run. Their screening comes back perfect. The amount of income is 4 times the rent, and they actually have money in the bank. Their previous management company just loves them, but unfortunately the unit they were in is going up for sale. And then you find out they have an emotional support animal. It's a 150-pound pit bull. What can you do? Well, if the tenant has a valid emotional support animal letter, then you must allow the tenant to rent the unit. Landlords can deny a tenant the request if the animal is a threat to the health and safety of others, or would cause substantial physical damage to the property. The housing provider's findings must rely on objective evidence about the animal's actual conduct. So if it's not behaving well, there's a possibility, but you cannot deny them based on the breed or size. There is one gray area you might be able to get away with. If your homeowner's insurance threatens to increase your rate or terminate your insurance, then it could constitute an undue burden upon the landlord, in which case you may be able to deny. So this tenant swears that this pit bull is an emotional support animal. Now you're not allowed to ask them, well, why do you need an emotional support animal? Unfortunately, this is all medical HIPAA rules, but you can require them to produce an emotional support animal letter. Now, per AB 468, to be a valid emotional support animal letter, it must come from a licensed healthcare practitioner with the following criteria. It must have a license in their profession. It must be active and valid, and it must be in the state that they're renting. They must have provided service within the scope of their profession. The client-provider relationship must have been established for at least 30 days prior to the letter being written. The health provider has completed a clinical evaluation of the client regarding the need for an emotional support animal letter and provided the tenant with a notice that faking a service dog is a misdemeanor. For the tenant's emotional support animal letter to be official, it must include the tenant's name, diagnosis details, and a recommendation for emotional support animal letter to help treat the mental or emotional disability. It needs to be written and signed by a mental health professional who is licensed in your state. Now, if the tenant fraudulently represents the animal identified as a guide dog or a service dog with a fake certificate identification, a tag, a vest, a leash, the harnesses, we've all seen them, then they are guilty of a misdemeanor punishable by imprisonment not to exceed 6 months or a fine not exceeding $1,000 or both. Since emotional support animals fall under medical privacy laws, an owner or manager must be careful about how they question the validity of an emotional support animal letter. One of the easiest and safest ways to validate an emotional support animal is to hire a third-party screening company. Yes, there are pet screening companies that are out there and have all of this figured out for you. Prescreening.com is one of these companies, and they claim that 60% of the emotional support animals that they review have found it not to meet the federal guidelines. So in the case of the pit bull, if the tenant can produce a valid emotional support animal letter, the animal is good-natured, and it does not cause the property owner any undue burden for reasonable accommodations, then the tenant is legally allowed to move in. If you'd like to see any future topics, please leave a comment down below, and thank you.